LAW578, Law of Evidence 2, Lecture 1, Witnesses and Corroboration. In our previous video, we have looked into matters relating to witnesses, that is focusing on competency, compellability, and privilege. In today's discussion, we are going to focus on the other aspect of witnesses' evidence, that is the one require corroboration. So, therefore, the discussion from this PowerPoint is actually to look at the concept of corroboration, where it is understood that some witnesses require their evidence to be supported, and this is the support that is meant by corroboration. And those witnesses are the one that relates to a child, evidence of sexual offences, evidence of an accomplice, accessory after the fact, agent provocateur, hostile witnesses, co-accused as a witness. Now, when we talk about witnesses being called in the court, Section 134 basically says that there is no hard and fast rule as to how many numbers of witnesses can a person call to give evidence in the court. Now, if you refer to Section 134 of the Evidence Act, number of witnesses, no particular number of witnesses shall in any case be required for the proof of any fact. So basically, this particular provision gives some kind of privilege to the prosecutor or to an accused person or counsel in a in a criminal case to call whoever they think relevant to their case. Similarly, if you are talking about a civil case, there is no hard and fast rule as to the number of witnesses to be called, either by the plaintiff or by the defendant, right? And there is a maxim that evidence is to be weighed, not counted. This is basically established in the case of the wagon. This case or this maxim basically reflects that what is important is the quality of the evidence and not the quantity of the evidence. One credible witness may outweigh any number of other witnesses, right? So because of that, because what is important here is that if a person testifies in the court, it is the quality of his evidence that is very, very paramount. However, we cannot deny the fact that in some situations, in some witnesses, support need to be given because perhaps of the label attached to that particular witnesses. So we are concerned with the situation where in some cases, some witnesses may have some issues relating to their credibility when they testify in the court. Because of some issues of their credibility, their evidence requires to be corroborated. Now, what is corroboration? If you look at the PowerPoints here, definition, corroboration is basically referred to evidence that support a fact or testimony of a witness. So when you talk about corroboration, you are basically talking about evidence in support. So you have a witness testifying in the court, and he falls under one of the categories of witness that is an issue, that has an issue relating to credibility. So whether there's any other evidence that can support his evidence, that is what it meant by corroboration. And the principle of corroboration has been established through the case of R. and Baskerville. We have this case as early as 1916, where it was stated that corroboration must be an independent testimony which affects the accused by connecting or tending to connect him with the crime. It must be evidence which implicates him, that is, which confirms in some material particular not only the evidence that a crime has been committed, but also the accused committed it. So the principle established in the case of Baskerville is that there are some characteristics of corroboration that you have to bear in mind. Number one, the corroborative evidence here, if it is produced in the court to support a witness evidence, it has to be an independent evidence, independent from the person testifying. It has to be relevant to the facts and issue. It has to be a credible evidence, admissible, and implicate the accused person in a material particular. So what happened here is that the case of Bakaran against public prosecutor, it stated that when you talk about corroboration evidence, corroboration can either be direct evidence, it can also be circumstantial evidence as long as it is admissible. So what does it mean? So it means that if you have, for example, here a person giving evidence in the court, so this particular person perhaps is charged together. Sorry, you have a person here, he committed a crime, and say for example he's committing trafficking, right? He committed trafficking of drug, and he committed the crime perhaps together with W. However, W basically has some deal with the prosecutor. W is not charged. W, however, become prosecution witness. So you have a situation where W here, who involved in the commission of a crime together with A, however not charged as a co-accused, but instead he become a prosecution witness. So you are going to have an issue here. If W here is to testify in the court, remember he is what we call in law accomplice. He involved in the commission of the crime, but now giving evidence for the prosecution. There is some interest in the case, and W here, when he testifies in the court, he may be giving relevant evidence. His evidence may be relevant because he may be narrating what transpired in the commission of a crime. He may give evidence in the court as to how the plan took place, how the crime took place. So basically, he can give relevant evidence when we talk about it, maybe under same transaction. He can give evidence of state of thing under Section 7. And now the issue here is, how much weight must you attach to this particular person? If they are giving relevant evidence, must their evidence be corroborated? Because eventually you find that W here has an interest in the case. All right. Right, so if you look at, so we look at Baskerville. So what happened here is that when we refer to Baskerville case, basically in the case of Baskerville, it says that if this particular W here giving evidence in the court, of course there's issues relating to his credibility, and Baskerville basically says that if this person is testifying in the court, make sure that the evidence here is corroborated, and what you got to find here is that the corroboration has to be independent. Yeah, it has to be independent. The corroborative evidence has to be relevant and admissible, and it has to implicate the accused person in a material particular. Now, what does it mean by this? Say if you have a situation where A is trafficking drug, you have W here is giving evidence in the court, and W here is an accomplice, right? So he may give evidence which are relevant, maybe under Section 7 state of thing. He testified relating to how the incident of trafficking transpired. Maybe he can narrate the beginning and the end of the incident. So basically maybe Section 6 of same transaction. So his evidence is relevant. However, by virtue of the nature of W here having an interest in this particular case, you have to find another evidence that can support his case. So what happened here is that maybe you can give evidence of Pak Gat, right? So you have here Pak Gat now testified or called to testify in the court. Pak Gat was there at the scene of the crime who saw the incident of trafficking, say, right? Or you may have maybe a passerby, right, who basically saw them buying and selling the drug. Or you may have a CCTV, that captured the image of A here selling to another person. So what happened here is that these are evidence that may use to corroborate W's testimony against A. So Pak Gat here, who may have seen A is selling the drug to a purchaser P, so Pak Gat here is basically bringing corroborative evidence. You have basically the passerby, you have the CCTV that captured the image. So what happened here is that W here, when he testified in the court, his evidence is corroborated by independent evidence of Pak Gat, passerby, or the CCTV. Alright? Now remember, the evidence, the corroborative evidence can either be direct evidence, it can also be circumstantial, in the sense that, say W here testifying in the court of the fact that A is carrying with him 1.2 kilogram of white powdery substance, which is heroin, and you have 1.2 kilogram of substance taken by the police from A's possession, and it was sent to a chemist, and this particular chemist analyzed this particular substance, confirmed it to be 1.2 kilogram and confirmed it to be heroin. So what happened here is that the chemist here is giving direct evidence to confirm the identity of this particular drug, right? The subject matter of the facts and issue, corroborating what the witness testimony. Yeah, so that could be direct evidence. Yeah. All right. So, as I told you just now, it can also be circumstantial, where you may have the passerby here saw A, selling drug. Yeah, it can also be direct. Yeah. Okay, A here selling drug, or you have here the police officer conducting a search, right, in the premises owned by the accused person here, and when the police officer committed a search, they basically found some weighing machine, they found some substance that may be used to manufacture the drugs. So this particular evidence, when it is standard, it will amounting to corroborative evidence to say that A is actually maybe involved in trafficking drug, right? So that is what it meant by corroboration. Yeah, so we have to understand it in the context of the case of Baskerville. All right. Now, when we talk about corroboration here, so let's look at the notes a little bit. So that is corroboration, and there are basically two types of corroboration. That is corroboration as a matter of law, and the other one will be corroboration as a matter of practice and prudence. Now, what does it mean? When you talk about corroboration as a matter of law, it means that you have a particular act, a particular provision, maybe in the Evidence Act or even in other statute, which requires corroboration to be tendered. It means that you have a particular witness here giving evidence in the court, and the specific provision basically requires it to be corroborated, right? Now, in this situation, what happened here is that when the judge considered the witness evidence, since the law required it to be corroborative, yeah, so the judge has no power, has no discretion but to look for the corroboration. So it means that the evidence of that particular person cannot be accepted by the court unless and until it is corroborated. It is because maybe the witness that you are talking about here has a problem relating to the credibility, right? And you have examples of corroboration required as a matter of law when you are talking about a child witness, right? And the second one will be corroboration as a matter of practice and prudence. This is where, the law does not specify clearly. The law does not specify clearly that corroboration is required when this particular person, witness here giving evidence in the court. However, there is some concern of the court as to the credibility of this particular person testifying. So because of that, the trend of judicial decision is that we require corroboration as a matter of practice and prudence. So this is not mandatory, and normally in situation where you have corroboration is a matter of practice and prudence, there will be a need for you to have at least corroboration warning. So what we have here, if you have a corroboration warning, you have a situation here where the judge basically looking at the evidence of that particular witness warn himself as to the danger in admitting that particular witness's evidence without corroboration. Right? Examples of corroboration as a matter of prudence and practice. Here you have that evidence of accomplice, where we are going to look at section 114, illustration G, and section 133 of the Evidence Act. Okay. Now, so as I told you of the fact that there are some witnesses that have issues relating to relating to the credibility. Therefore, the laws decided that their evidence has to be supported. And one of the evidence that we are going to discuss will be the one related to child witness. Now, when we talk about a child witness here giving evidence in the court, there is a general rule that child cannot be trusted. Child evidence has to be treated with caution. You have quite a number of cases. There have been quite a number of cases under the common law. But in Malaysia, you have this in the case of Chow Cheong. You have this in the case of public prosecutor against Chan Cheong Tiong, whereby it has been established principle that sometimes children cannot distinguish between fantasy and reality. Meaning to say that child tend to fantasize, they cannot distinguish between fantasy and reality. Therefore, because of the special nature of this child, if they are to testify in the court, their evidence has to be scrutinized with caution. Therefore, they need to have, in some situation, corroboration. Now, when you talk about a child here giving evidence, there's always two issues relating to the child being a witness. Number one, issues relating to competency, and the other one will be issues relating to corroboration. Now, when you talk about the child giving evidence in the court, the first question will be, the thing that you have to ask is that, is the child competent to testify? Does she has the capacity to testify? Right? That will be the issues that you have to discuss. Number one, relating to the competency of a child to testify in the court. And number two, you are talking about, must a child, if she gives evidence in the court, must his evidence be corroborated or be supported by independent evidence? So that will be the second question that you have to ask if you are dealing with evidence of a child. So we're going to address these particular issues relating to child witnesses. Now, when you talk about so if you have basically a child witness, I told you just now, we found out that there are two issues relating to a child, whether the child here is competent to testify, and number two, if a child is competent to testify, must her or evidence be corroborated? Right. Now, when we address the issues of competency, whether a child competent to testify or qualified to testify, you basically have to look again to section 118 of the Evidence Act. We have discussed section 118 in the previous video, but we just recall it for the sake of continuation of discussion relating to a child witness. So when you talk about evidence of a child, is a child competent to testify? Let's look at section 118. All persons shall be competent to testify. So it means that it doesn't matter who you are competent to testify. You can be a witness appearing before the court. But you have that unless the court considers that they are prevented from understanding the questions put to them. So, general rule, every person are competent to testify. However, here you have unless, right? Meaning to say a person is able to testify in the court or competent to testify in the court if he understands the question put to them, and number two, he is able to give rational answers to those questions. So these are the two factors that you have to consider to determine whether a child can give evidence in the court, whether the person understands the questions put to them, or whether the person can give rational answers to those questions. Right? It means that if you refer to the earlier case that we have discussed here, you have the case of Arumugam, you have the case of Siddiq bin Ludan, you have the case of Yusaini. Basically, this case says that, right, for a child to give evidence in the court, basically, there are two kinds of evidence in the court. Of course, the child must be able to understand the question put to them and must be able to give rational answers to those questions. And the kind of evidence that the child can give evidence in the court will be of two forms, right? The kinds of evidence that the child can give sworn evidence, and the other one will be unsworn evidence. Of course, the cases that you have to bear in mind will be the cases of Yusaini, the cases of Arumuga Motaya, and the case of Sidik bin Ludan. You also have the case of Tajuddin in our previous video. Now, what does it mean by a child giving sworn evidence? The provisions that you have to look here is basically, or the guideline that you have to refer to here, will be the provision under Section 133A of the Evidence Act, read together with all those cases. Now, let's look at Section 123 here. So, you are now determining whether a child can be competent to be a competent witness. Look at Section 133 of the Evidence Act. Evidence of a child of tender years, where in any proceedings against any person for any offence, any child of tender years called as a witness does not, in the opinion of the court, understand the nature of an oath. Right? So when you look at the kind of evidence that a child gives, he can give sworn evidence, that is evidence taken on oath, and the other one will be unsworn evidence. Yeah? Right? So when can a child give sworn evidence and when can a child give an unsworn evidence? Okay, now let's look at this provision. A witness does not, in the opinion of the court, understand the nature of an oath. His evidence may be received, though not given upon oath, if, in the opinion of the court, he is possessed of sufficient intelligence to justify the reception of the evidence and understand the duty to speak the truth, and his evidence, though not given on oath, but otherwise taken and reduced into writing in accordance with Section 269 of the CPC of the Federated Malay States, shall be deemed to be a deposition within the meaning of that section, provided that where evidence admitted by virtue of this section is given on behalf of the prosecution, the accused shall not be liable to be convicted of the offence unless the evidence is corroborated by some other material in evidence in support thereof implicating him. So basically, under Section 133A, you have two parts of the two parts of the law. The first part is talking about the competency of a child, whereby, if you read the provision just now, we find that if a child has sufficient intelligence, so if a child here has sufficient intelligence, and understand the duty to speak the truth, so this particular child will give unsworn evidence. This particular child will give unsworn evidence, meaning to say that he can appear before the court, but he is not going to take oath. Here, what you got to understand here is that the child must be able to have, the child must have sufficient intelligence and understand the nature of duty to speak the truth. So it means that the child here understands the obligation, the duty not to lie in the court. Normally what will happen here is that if you have a child maybe of 10-year-old, right? Remember, a child, when they were from very small, they were instilled from the fact that they have to be morally right. They must not lie in the court. Basically, the parents will always teach them to tell the truth, never lie to another person. So if the child understands that they must not lie to another person, they believe that there is a moral obligation that they must speak the truth, then this kind of child will give unsworn evidence. However, if the child here understands If the child here understands the nature and obligation of an oath, then the child can give sworn evidence. It means that the magistrate maybe ask the question to this child and tell him, do you know what is an oath? Basically, the oath is that where you take a stand in court. Yeah, you take an oath maybe in front of your holy sacred document. It means that you understand the nature of an oath. If you lie, you will be subject to perjury. Then this particular child basically understands the nature of an oath. He or she can give unsworn evidence. Right? So it means that if a child here just know the duty to tell the truth, must not lie in the court, the child will give unsworn evidence. But if the child here understand what is the meaning of an oath, right? Understand the implication of perjury, lying in court, so the child can give the child will give sworn evidence. So if the child gives sworn evidence, the evidence will be at the same par, at the par with evidence given by an adult on oath. Right? So, when you talk about here, now how do the magistrate know whether this particular child here is giving evidence, sworn or unsworn evidence? Right? To determine whether a child basically gives sworn or unsworn evidence, the court has to conduct preliminary examination. Now, this preliminary examination has to be conducted even before the child is called to testify. So, this is a process that must come before a child basically give evidence in the court. Preliminary examination, you have to observe with the strict law of evidence. What will happen here is that normally before the child testifies in the court, the magistrate may want to meet him face to face personally, maybe in her or his chamber, informally ask the question, gauge their intelligence, gauge their understanding if questions put to them. Basically, if that happens, then the judge will be able to come to a decision whether this particular person is giving sworn evidence or unsworn evidence. Yeah. So that happened in a preliminary examination, and you have that in the case of Usaini, Sidik bin Ludan. Preliminary examination is a compulsory. You have to get it done. Failure to conduct preliminary examination is fatal to a case whereby you have a child here, but the magistrate here did not conduct a preliminary examination to determine whether she is competent to give sworn and unsworn evidence. That can be a ground of appeal for the accused person if the judge consider the child's evidence. Yeah. So here you find that basically there are two kinds of evidence of a child here. That is a sworn evidence and unsworn evidence. Okay. Right. Remember, this is actually illustrated in the case of Sidik bin Ludan. You have that. So what happened in the case of Sidik bin Ludan is that you have basically a child, an accused person here who come to like the victim who is 9-year-old, right? And then you have the victim here has the sister who is 10-year-old, and she also has another friend who is 10-year-old, right? So what happened here is that the accused person here has been raping the victim. And the incident was actually captured or known by the witness as, the friend as, and F. So they basically saw the incident of A raping the girl V here at the hut, right? At the hut in a rubber plantation. So what happened here is that when an accused person here giving evidence in the court, when an accused person here is charged, the issue here, whether this particular evidence of V here, whether V here can be called to testify in the court, and what kind of evidence will she be giving in the court, whether it is sworn and unsworn evidence, you have to determine that in a preliminary examination. Now what happened here, during preliminary examination, the court discovered that this particular girl here understands the duty to speak the truth but did not understand the nature of an oath, so the court ruled that she can give an unsworn evidence. Now, when you talk about unsworn evidence, you have to bear in mind, basically, you have to bear in mind just now section 133A. You also have to bear in mind section 8 of the Oath and Affirmation Act 1949, whereby the court has a duty to allow the child to give an unsworn evidence, but the judge must be cautioned in treating the evidence because the judge got to determine whether the child understands the nature of questions put to them, and caution has also must be given by the judge to the child, and reminded her of a duty to tell the truth. So that will be the law that has to be observed by the child in allowing the law that need to be observed by the judge in allowing the child to give unsworn evidence. That is section 133A and section 8 of the Oath and Affirmation Act. So what happened in the case of Siddiq bin Ludan? Here you have, during preliminary examination, the court discovered that the child here, V, the victim, can give an unsworn evidence. And the friend S, who is 10 years old here, also give an unsworn evidence. And the child here, another friend F here, is giving unsworn evidence. Right? So what you have here, the child here is found to be competent to testify. Then you have the issues of the second part of the section 133A, whereby provided that where evidence admitted by virtue of this section is given on behalf of the prosecution, the accused shall not be liable to be convicted of the offense unless that evidence is corroborated by some other material in evidence in support. It means that when you have the victim here testifying in the court, because the nature of the evidence is an unsworn evidence, right? Their evidence has to be supported with an independent evidence as discussed in Baskerville. Now, when you talk about the case of Siddiq bin Ludan, remember this is a difficult case because you have a child here being raped. And what evidence that you have will be the evidence of S here, who is a 10-year-old, who also gave an unsworn evidence. And the evidence of F here, who is also giving an unsworn evidence, which is basically not strong enough to become corroborative evidence for evidence of V here. So in this situation, according to the case of Baskerville, the court must look at other independent evidence, right, to support this evidence in court. So what happened here, you basically have, in this case, the teacher who observed the change of behavior of the victim after being several times raped. So you have the teacher here. And of course, the victim here being brought to see a doctor. Maybe you have Dr. K here. And of course, the victim here is telling the mother as to what transpired. So you have the victim here, her evidence is corroborated by the mother who got the information of rape from the victim's mouth. You got the teacher here who also got the information that she was raped from the victim herself and from her observation of the fact that there's change of behavior. She was a very jovial girl before, now she's very sad and always cry. And you also have the evidence of Dr. K, who got the information of rape from the victim herself, and also the fact that she made an examination and found there evidence of rape. Now, if you look at this situation, remember section 133A says that evidence of V here has to be corroborated. It means that you have to find an independent corroboration as per Baskerville. And you find that evidence of V here, once it is corroborated, if you are relying on the evidence of S and F here, this is a very weak corroboration evidence. S and F here give you a very weak corroboration evidence because they themselves are uncorroborated. They are giving unsworn evidence in the court. Right? Now, when you talk about here, the girl here, W here, is giving evidence, is now being the victim of rape. How about, can her evidence here be supported by the mother? Remember, the mother got the information of rape from the victim themselves. Now, will that be a strong corroboration? If you recall the meaning of corroboration in Baskerville, remember it has to be an independent, relevant evidence which can, it has to be an independent, relevant evidence which implicate the accused person in material particular. However, in this context, the evidence of V here, the evidence of W here, the source is actually the victim, that is V. And there's a problem with this evidence. If W is to testify in the court, the kind of evidence that is given by W here actually fall under section 157 of the Evidence Act. Yeah, we will look at section 157 afterwards, yeah. Now, here you have, now the second witness here, you have the prosecution here is calling the teacher. So the teacher will testify in the court as to the fact that what V told her. So this is again fall under section 157. There's some problem with it. However, the observation on the changes in the attitude, in the conduct of the victim is relevant as an independent corroborative evidence, complying with the definition of Baskerville. Basically, the observation of the teacher here can reflect maybe evidence of conduct, it's up to change of conduct, may also be evidence of observation under section 7 state of thing. So this is going to be a good evidence because it is an independent corroborative evidence which may implicate the accused person, right? And the third one here, you have Dr. K here. So evidence of Dr. K here comes, okay, she obtained the information of rape from victim. So this one fall under section 157. And of course, you have the other one is that she conducted an examination. When she conducted an examination, she found that she has been raped. So the evidence of examination here will be an independent, direct evidence of possible rape, right? So this is a good corroborative evidence. The teacher observation is going to be a good corroborative evidence, but the rest is not going to be good enough. Now, why is the evidence of W here? Yeah, under section 157, the teacher statement from V here, and Dr. K, who got the information from V here, is not good corroborative evidence. It falls under statement under section 157. Now, let's look at section 157. What does it say? Now, section 157 basically says that, right? It basically says that former statements of witness may be proved to corroborate later testimony as to the same fact. In order to corroborate the testimony of a witness, any former statement made by him, whether written or verbal, on oath or in ordinary conversation, relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate that fact, may be proved. Now, section 157 here is basically referring to corroborative with corroboration that comes from the consistency of the statement. So you have under section 157 here, you are talking about former statement made by V. So you're talking about a former statement here. The maker of the statement here is V, the victim who has been raped, a child victim who has been raped. So you're talking about the former statement that he or she made to another witness. And what happened here is that the other witness here is simply repeating what she said. That is what it meant by former statement made by him. So what happened here is that W here will be testifying in the court as to what we said. The teacher here will be testifying in the court as to what we said. Also Dr. K. Now this is actually very weak corroborative evidence. Yeah, later we will look at the notes. The fact that under Baskerville, this is not corroboration, right? It is not going to be strong independent corroboration, but it is a relevant evidence nonetheless to reflect the consistency of the statement. So if you're making a statement that, say for example, you have been snatched theft, you tell the story of the fact that you have been snatched theft to witness number 1, number 2, number 3, that will reflect the consistency of the statement, right? Now, under the law on corroboration, statement under 157 here will be very weak corroboration evidence, right? It's not as per Baskerville, yeah? It cannot be used to really corroborate the evidence of a child witness here, all right? So you got that here. So what happened in the case of Siddiq bin Ludan? Basically, you have an accused person here being charged, right? You have an accused person here being charged, and you have witnesses of the victim here, who is an unsworn, given sworn evidence. Yeah, as here, very unsworn evidence as well, which is very weak corroboration. Yeah, F here, unsworn evidence, and you have evidence of W here, fall under section 157, evidence, very weak corroboration. So the child here, their evidence is basically corroborated by the evidence of a teacher, right? This is going to be good corroboration by the teacher. It's going to be good corroboration by the doctor. So that's what happened in the case of Siddiq bin Ludan, right? So the court has to evaluate, has to consider all these things before coming to a decision whether to use or not evidence of this particular child. So, okay, what we have discussed just now, basically, is a child competent to testify? Yes, we have looked into section 118. Child are competent to testify in the court. We have to ask the question whether they understand what is an oath, whether they understand the moral obligation, whether they understand the duty to speak the truth, must not lie. Basically, the child can give either sworn evidence or unsworn evidence. Yeah. So you have this one. The notes on the fact that you have to conduct a preliminary examination prior to allowing the child to give evidence in the court, and the child can give sworn evidence and unsworn evidence, right? Okay, this will be the law that requires child giving unsworn evidence, meaning to say that she can testify, but it is a requirement of the law that the child evidence has to be corroborated. There is no way you can convict the accused person based on the child evidence alone without corroboration, right? So if the child understands the duty, the nature and moral obligation of an oath, she can give sworn evidence. Okay? So this is what we have discussed just now. So a child therefore can give sworn and unsworn evidence. Remember, I have also discussed with you consistency statement under section 157. So with that, we complete discussion on child witnesses, requirement of competency, and requirement of corroboration. We will continue in the next video talking about evidence of victims of sexual offenses.